Proud Boys trial day 39. We are catching up on the day's activities. Of course, we know who is on the stand. His name is Capitol Police Officer Mark Carrion. He was in the Plainclothes Division Civil Disturbance Unit. He is being directly examined by the U.S. government prosecutors. We've got Jason McCullough, Eric Kennerson, Connor Monroe, and I believe Nadia Moore was the prosecutor who was doing the direct exam. We'll check in and see. The defense attorneys are all in the house. We remember that we've got many of them representing the Proud Boys, each of whom you see on your screen. Let's turn our attention to the court docket before we see what else is going on here. Now, back on March 17th, we had a proceeding in court. The jury trial resumed. Everybody was there. And let's take a look at the trial thread and see what happened. Roger Parloff tells us, it's March 17th. Day 39, Proud Boys trial. I'll be live tweeting here and on Lawfare. The government just began its direct exam of its 21st and last government witness. Capitol Police Officer here in the Capitol building. Now, we're waiting for the judge to get on the bench as we scroll through our friend Roger Parloff's Twitter thread. And boom, we get it. Judge Kelly arrives on the bench. He says, all right, ladies and gentlemen, it's good to see you back here. Happy Friday. Grateful to be here. Says, all right, before we call the jury in, we just got 3 things that we want to attend to before we get started. Number 1, we were asking about this limiting instruction. Remember a couple days ago, we were talking about Nordine and Biggs and whether the videos, especially those drunk videos, could be used to show certain things. And here, the Nordine and Biggs videos, those were only going to be used for state of mind. He says, I'll give the limiting instruction to the jurors, and that's that. He's also going to strike some testimony. Yesterday, Officer Mark Carrion, who's still on the stand, made a reference to some radio alerts that he received on January 6th of some bomb threats, who is still not found. That random Fed bomber, whoever that was. Don't know who that is. And number 3, the judge says, and so I'm going to redact that. We're going to delete the reference to the bombs. I don't want the jurors to get distracted. And he says, lastly, I'm going to continue to look at these messages. Apparently, he's doing what's called an in-camera review, which means he's looking at stuff in his courtroom. An in-camera review of the messages that were deleted from the spreadsheet. If you remember, FBI agent Nicole Miller testified. After she was done testifying, she was supposed to disclose her Jenks material over to the defense. And in that Jenks material, it was an Excel spreadsheet with a bunch of rows that were deleted, or let's say hidden, thousands of rows. So the DOJ sent that spreadsheet back over to the judge and they said, all right, we don't know what's in these rows, but why don't you take a look at them and you'll let us know what to do about all this data. So the judge says, all right, I'm going to continue to look at the spreadsheets. The original one that was provided to the defense that allegedly had the, quote, classified or sensitive info. You remember all that? The FBI just made up a whole new category and they said, we can't give this stuff back over to you, defense, because it's sensitive info. So Roger says, now they're discussing a witness that Nick Smith, one of the attorneys, might call as a defense witness as early as Monday, coming up tomorrow. Says that this witness is going to be a Proud Boys videographer. His name will be Eddie Block. He's in a wheelchair and he wants to bring a service dog. Prosecutor says, oh, that's no problem. The government is pro-dog and I think we can accommodate him. And I think that might be what this recent filing was. Yeah. So here it looks like response by the United States. Looks like, are they going to let the dog come in? That'd be nice if they did. Here, let's see if we can just see this dog motion real fast. See if they'll pretend like they're nice people. We'll open this one up here. Let's see what the government says. Hopefully they don't say execute his dog. Oh, maybe they'll charge his dog too. Maybe he should be indicted for being man's best friend during a Proud Boy insurrection. Here's what they say. This is the government's response to a motion permitting a witness to testify by a service dog. The government says, Eric, he writes, on March 15th, Nordine filed a motion to permit Eddie Block to testify, accompanied by his St. Bernard, who's a real good boy, which he asserts is a service and therapy dog. Oh, the government hereby notifies the court it takes no position, losers, on the defendant's motion. Accordingly, the government defers to the court. What a bunch of jerks. Can't you just say no objection? Gosh. All right, look, there's an objection. Then there is no objection, and then there's no position. They took no position. Apparently they hate dogs. Typical government prosecutors. Not even surprised. All right, so let's go back over. So apparently no position, and the judge will decide that tomorrow. Roger Parloff, says it says the judge is going to consider accommodating him. Now bringing in the jury. Judge brings him in. We set him down. All right. Now, the witness on the stand is Mark Carrion, U.S. Capitol Police officer. He was in the CDU, the Civil Disturbance Unit. And on this day, on January 6th, he was a part of the soft squad, so no riot gear. He was stationed on the east side of the Capitol. So the jury is back. They're all seated in. The judge says, all right, ladies and gentlemen, just a reminder, some couple items to housekeeping things to go over here. The videos that you heard yesterday, the statements on the podcasts, those are evidence about their state of mind. State of mind. We're not asking you to look at the content of the video to determine what they did in the video. We're just asking about their state of mind. That's the only thing it's useful for. They say, okay, we understand. And they probably don't have any idea what he's talking. They say, we're also going to strike the testimony about the bomb alerts. I say, okay, that makes sense. And they don't know what that means either. Okay. So it goes on, and they're now bringing out Officer Mark Carrion. Prosecutor, we recall Mark Carrion to the stand. Officer, you're reminded you're under oath. You understand? Yes, I do. So Nadia Moore is going to be resuming the direct exam. And Nadia Moore is this prosecutor here who we found on LinkedIn. And here's what she says. All right, officer. We left off testimony talking about the bike racks. Do you remember that? Yeah. After the bike racks were breached near that Senate egg, and that egg is that little corridor. It sort of looks like an egg on the map. There were those of us, he says, what happened next? He says, well, after all of that, those of us on the southeast side, we started running toward the memorial door. We posted up in front of it. It's on the ground level, and we thought that they would rush that door. So we protected it. Well, how long were you there? He said, well, about 2 to 3 minutes. And then we saw a crowd not noticing the memorial door, sort of south of the Columbus doors, but it was over at the ground level. And then they were running up the steps toward this other door. And so we ran in that direction. Says, okay, and you're showing us all this on the map? Perfect. Says, okay, now can you tell us where these officers were going? And so Carrion is now pointing out the line of police officers trying to stop the protesters from going up the steps. So he says, yeah, they're right here. Protesters are running up this way. We're running down that way. And we were there to try to stop them. What happened next? She said. Well, after they created the line, the officers, then the crowd broke through them and started running up the staircase. And we could see officers having issues. And so we made our way up the left side. And what happened next? Well, there was a race, like a rush right up to the door. About what time was that, officer? Actually, no, sorry. That's Carmen Hernandez. So a defense attorney races in there. All right, I got to back up on this. So she's in the, so the prosecutor's in the middle of her direct exam. Okay. And he's explaining, we made our way up the left side. There was just a rush up the door, and the defense chimes in from across the room and shouts, can we have a time? Like, what time are you talking about? What time? It's not her time to ask questions. So the judge says, it's the government's presentation, Carmen. You may proceed. Now we're seeing more video of the rioters on the steps pushing in a heave, right? We saw the many videos of this. What's happening here, officer? Well, they're pushing. Obviously, they're trying to get through. And what happened to the police line? He says, well, at that point, the police line was overrun. Objection, relevance, says Carmen. Judge says, sorry, Carmen, overruled. You may go on. So he says, yeah, so there's more video here. They're playing all the video. You know, they want to just play this thing on loop as much as they possibly can because it's really useful for them. It doesn't look good, so they just over and over and over. More video panning across the street showing rioters overrunning it, rioters surrounding, climbing on police vehicles, and so on. Carrion says, yeah, and we were also standing outside of the Columbus doors. There's sort of wooden doors in the area. And we also refer to those doors as the exterior rotunda doors. It leads obviously directly to the rotunda. That's why we call them the exterior rotunda doors. Geniuses there. I was behind one of the columns, he said. I could hear the alarm, meaning the door was open and unsecure. It was just beeping, beeping, beeping. And so we formed a tactical position. I called all my officer friends and we call it a wedge. And so we tried to push as many people back to create a space. Is that what that looked like right here, officer? Yeah, so they paused the video and he says, yeah, right here. See, that's me and those are my officers and we're all standing on the line. And what happened next? And he said, well, our radio was going crazy. So we had the West Side officers calling. Everybody was calling for help. Objection! Overruled. Go on. He says also the crowd was yelling and they were chanting. I mean, our senses were overwhelmed at that point. Carmen, defense attorney, says, Judge, look, can we have a sidebar, please? Picks up the phone, sidebar. They're talking. Carmen Hernandez is very upset about this. And remember, she's representing Zachary Real. So let's take a look at this defense attorney who is the subject of some discussion here. Carmen Hernandez for Zachary Real. Parloff continues. Prosecutor says, well, what was the crowd doing next? Capitol Police? Well, they were pushing back against us. They were also being pushed into us because more and more people were coming up the stairs. So there was kind of this heave-ho action. I want to play this next part of the video for you. What's happening here? Now there's violent fighting at the Columbus door. Rioters are spraying the police, he says. Carmen says, objection, I move to strike. Judge says, nope, overruled. That can come in. So he's making characterizations, right? Rioters are spraying at the police, and she doesn't like that. Objection, that mischaracterized. You know, he's not qualified to say what that was or whatever. And objection, overruled. Judge says, you're fine, go right ahead. So he goes, well, there were 5 or 6 of us left at the door. We were being sprayed. We had OC spray and mace. They were hitting us with flagpoles. They were hitting us with batteries and frozen water bottles. Oh, it was maybe that frozen water bottle. That was the one in the indictment, frozen, in hopes of getting us out of there. Crowd grab. They probably saw my video making fun of their water bottle indictment. Glad that testimony got fixed. In hopes of getting us out there, the crowd grabbed the riot shield from the officers. Objection! Carmen Hernandez is still sitting there. It mischaracterizes. That's not evidence. He wasn't there. He's speculated. Objection. Probably overruled again. Now, Carrion says, all right, now we're looking at the Columbus exterior door and the landing area from the south side. 2 other defense attorneys now, Stephen Metcalf and Dan Hall, chime in, and they say we have continuing objections. Stephen Metcalf is down here representing Dominic Pizzola, so they're objecting to this entire line of inquiry. And J. Daniel Hull, who we've not actually heard much from, he's a Washington, D.C. litigator representing Joseph Biggs. He's also there objecting. So we've got many objections. We have a continuing objection as to relevance. Don't know why he's talking about all of this. He's talking about people who presumably are not even the Proud Boys themselves, right? The crowd grabbed the riot shield. Did okay? Were the Proud Boys in the crowd? Like, did one of the 5 people who's being charged with a crime, did they do it? No? Then what else are we talking about here? Did they hit you with the flagpole? Which one of them hit you with a water bottle? Like, why are you talking about this horrific thing in order to make this look bad for these co-defendants? Because they're not responsible for these things unless you're alleging they are. Maybe you are. Now, we have to see. Carrion says we saw 3 of our officers leave, 2 of which got sprayed in the eyes, directly in the eyes, which is a very dangerous situation for them. Pattis objects. Judge, he's not qualified to determine whether that's dangerous or not. He's just a regular police officer. That's Norm Pattis, probably an objection like that. He comes back and says, overruled. You're allowed to talk about whatever you want here. This is my courtroom. Government gets full reign. Continue on, good sir. Hero of America. Please continue, says the judge. He says, our lieutenant and our sergeant also got sprayed in the eyes. People pushing against them and they can't see. We had one of our officers escort them out because it's dangerous for them when they say they can't open their eyes. He says, so it's only me and my officer Salke were the last 2 left. We had individuals trying to grab our hands, our arms to release the door. Officer Salke grabbed the flagpole from a rioter, broke it in half, placed it through the door handles. We grabbed flagpoles to prevent doors from opening. Through the windows in the East Rotunda, I saw the yellow "Don't Tread on Me" flag. That's when I knew the Capitol had been breached and people were inside. They play some more footage on loop. Around and around we go. At this point, the interior door had been breached. The flagpole was snapped in half and the doors were coming open, and we were eventually overrun. What happened next, officer? He says, the crowd started pouring in. I was on the left side and beside the door, still trying to close it to minimize the amount of people coming in. Officer Salke was in the middle, trying to restrict people. Now they're playing CCTV footage. Broken windows, furniture misplaced. Hernandez objects again. Your Honor, totally irrelevant to our client's behavior or conduct. Sidebar. She makes her argument. The judge probably tells her to shut up again. Says, carry on, sir. So he does. Officer continues. I was toward the right side of the door as we see it. Now we see the rioters surrounding the doors, and there are a few officers, but they're all outnumbered. We see rioters inside. Now, Officer Moore says, Prosecutor Moore says, officer, is this you? Circles this one. Yeah, that's me. And is this Officer Salke? Yes, that's me too. What are you guys trying to do in this scene right here? when on this video? What are you trying to do right now? Well, we're trying to restrict flow. Objection! Objection overruled. Carry on, sir. We're clearly outnumbered and overrun, he says. We're trying to put our bodies in the way to minimize the amount of people coming in. Video plays forward, the alarm still blaring. Now the crowd is chanting treason. Once in a while, we would close the door, he says, but the hinge on the door broke. So we weren't able to secure anything. The only way to secure was to push people out. So we closed the Columbus doors. Then we took the iron benches and threw it into the set of doors. Why'd you do that? Well, we didn't want the doors to swing open again. And so we took a moment and we walked into the Capitol and saw nothing but officers exhausted, using water bottles to hose off spray. What time did you leave the Capitol? About 11 o'clock that night. Objection overruled. Can we be heard on that, Judge? No, you can't. Sit down. Stop objecting. Look at this. Objection. Oh my God. I don't even know what it's like to be in this courtroom right now. It's just crazy. Hernandez, objection, overruled. Can we be heard? No. Hernandez says, well, I object again. Overruled again. Somebody else objects, another defense attorney, and you're overruled. Again. So the prosecutor says, Judge, can I be heard? And he says, of course. What can I help you with? Sidebar. Sidebar, they just go ahead and have a conversation. He's like, I love you guys. What's up over there? Sure. I'd love that for lunch. Yeah. Get me the big one. No, I'll pay. You guys are doing great. I'll pay for it. Don't even worry about it. Defense is over here with their hands up. Put your hand down, Carmen. So they get off the phone and now more is done. Prosecutor is done. So our final officer, we ask ourselves about cross-examination. Are there going to be any? We ask Nick Smith if he's going to chime in for Nordine. And it looks like the answer on that one is no, he is not. So Smith, no cross-examination. Dan Hull for Biggs, he starts a cross-examination. He says, Officer, what time did you get to the Capitol? He said, about 8:30 in the morning. And where were you at that time? He says, well, I was on the west side of the Capitol, on the east side. He saw a pro-Trump crowd as soon as he started to arrive on the Senate egg. And you saw another pro-Trump crowd come around the west side past the north side. What time was that approximately when you saw that crowd come around? Oh, I couldn't tell you exactly. So you were there at 8:30 a.m. and then another crowd came around at what time? Couldn't tell you. Before noon? Don't know. Were the bike racks shaken loose at that time? He said, well, on the Senate egg, there were 3 instances where we'd see people shake the bike racks, like kick them down. He says, in my opinion, they were just testing our response. Well, what time were the bike racks shaken, officer? The 3 instances where we saw those were in the morning. Well, when was the first time? Sometime after 8:30. The second time? Don't remember. Well, how about the third time? Well, he said sometime before the full-on breach. I don't know. Well, when was the full-on breach? And Carmen objects to that question. So Carmen is objecting to another defense attorney's question because it hurts her client. You see this? Overruled again. When was the first time bike racks were actually pushed down? Nordine objects. Sustained. Okay, and remember, this is Hull speaking. So what I wanted to show you was this is Hull, who is representing Joseph Biggs, cross-examining a Capitol Hill police officer who is the government's witness being objected to by other co-defendant attorneys, right? Because they're getting questions out that are good for Joseph Biggs, but bad for everybody else. So these co-defendants are also in a tricky spot because not only are they against the government, but they're also against everybody else. Let's go back to the thread. When that objection was sustained, when did the rushing of the Columbus doors open, officer? He says, well, all of that was within about 10 minutes of the breach. And when were the doors actually breached? He says, well, in the videos, I think it was around 2:38 to about 2:40, around that time. And so we've got pictures of you here on the screen here. It looks like you and sulky officers are near the doors when they're closed, right? Yeah. About what time was that? He says, probably after 2 p.m. Thank you. No further questions. So now we have another defendant come in. So cross-examination is from now Carmen Hernandez on behalf of Zachary Real. She stands up and begins her cross. Hello, officer. Hi. First of all, I want to thank you for your service. He says, you're welcome. Now, your testimony was about Columbus doors. Is that right? He says, mostly. She says, no further questions. Oh, she's hilarious, man. So your testimony was about the Columbus doors. Basically is right. That's too funny. It's exactly what we were saying, right? He's talking about all of this other stuff, but he wasn't specifying anything that these guys did in particular. All the violence and all the water bottles. Did he say that we heard that any one of these guys threw it? Not that I know. So she says, so you're here on behalf of the doors, I guess? The doors? The hinges were coming off the doors? All right. No further questions for you. All right. Roger Roots now comes in, and Roger Roots, we're going to read a motion from him in a minute. This is Roger Roots representing Dominic Pizzola. He says, did you see my client Pizzola in anything of this ordeal you just shared with us about the doors? He says, no, not that I recall. Okay, but you saw hundreds of protesters, right? Yeah, I did. Thousands of protesters, maybe? He says, yeah, that was about the total for the day. Yeah, that sounds about right. Officer, when you were there, I mean, you saw misconduct, right? Yeah. You saw people doing bad things, didn't you? Yeah. You saw people spraying mace all over the place, didn't you? Yeah. And people pushing each other, yes. And violent, right? Yes. Many people were behaving peacefully, though, weren't they? Yeah. He says, did you detect that the crowd on the east side was being controlled by or guided by the people on the west side? Two sides of the building being coordinated? He says, well, the only thing I can speak to that is later on, sort of after the door was breached, we found radios, we found walkie-talkies, and we could hear communications happening between the both sides. That's interesting. Wonder what that's about. After doors were breached, we found radios and could hear communications happening. Did you hear anything that you can recall from those radios? Hernandez, objection. Overruled. No, I didn't hear anything. Now, officer, the crowd, would you say that it was mostly peaceful? He says, yeah, and actually it was until the breach, and then it turned into this mob mentality. Did you hear anybody throughout this entire day express anything friendly to you? You heard a lot of yelling and violence, but did you hear any friendly remarks? He says, well, we heard people behind us when we were holding the door saying, we got you, brother. Not going to let anything happen to you. That's nice of them. Now, he says, we thought that we had law enforcement and prior military in the crowd as well. We thought we had law enforcement and prior military in the crowd as well. Don't know if he means law enforcement who was there as law enforcement or law enforcement who were there as protesters, right? Protesters who also happen to be law enforcement. Don't know. The defense says, did it seem like the crowd on the east side had any kind of organized strategy? He said, yeah, in my opinion, yeah. Actually, we had two individuals. Nordine says, objection, sustained. Did it look like, calls for speculation. Did it look like anyone was commanding? Yeah, so I think those are, he says, mix those up. Objection, sustained. He says, well, I can't recall. Were you punched or were you hit? He says, well, I can't recall if I was punched or hit because of adrenaline. And I was wearing 3 layers of clothing as well. So I don't even know if I got hit at all. Which is by my clients? Any assault by my clients? Did you ever see my clients? No. I don't know what his clients are even, how they're implicated at all. Roots says, okay, we're done. No further questions. My client hasn't even been brought up here at all. Apparently, Tario's lawyers don't even have any questions. So Tario's people just say, no, we're done. No questions from us. So the witness just didn't even implicate them. So they don't have any questions for them. No redirect exam, so the government's done as well. Sidebar, they're talking. Looks like the government's case in chief might be over. The judge says, all right, I guess nobody has any questions and the government has no redirect. So I guess we're done here. Judge says, all right, well, we're going to send the jury home until Monday, 9 a.m. Ladies and gentlemen, please avoid any media coverage and don't conduct independent investigations and don't discuss the evidence. Have a great weekend. Attorneys stick around. Now, Carmen Hernandez, defense attorney extraordinaire for Zachary Real, she's chiming in. She's upset. She had her hand up all this week and she's not been called on a lot. And she moves to strike the testimony of this officer. She says, Judge, this is insane. He came out here. He didn't talk about any one of our clients. Nobody even wanted to cross-examine him. He's talking about doors falling off the hinges, saying I've been hit in the head with all this stuff, but nothing directly connecting to our clients. This is just like somebody coming in here and talking about a really bad thing. And then the jurors hear this person talking about a really bad thing and they imply that it's your client's fault. That's nuts. We talk about the rule 403, where if it's more prejudicial than it is probative. This is a great example. What testimony did we get from this officer that was useful in establishing the mental state or the physical conduct of any one of these 5 Proud Boys? None. She says there wasn't any of it here, Judge. And so she says all of it has to go. It was never linked to any of the defendants in this case. He was talking about the insurrection broadly, but they're not responsible for the insurrection broadly. They're responsible for their specific conduct. Government prosecutor Moore, she turns around and she says, Judge, that's not true at all. Are you kidding me? She says, in our exhibits, we've previously provided identification for Biggs and Fisher and Johnson and Hafner and Lorkey. And we've got all sorts of IDs and it's all relevant and it should be admitted because their conduct was in close proximity to everybody else's conduct and they were, whatever. And the judge says, good arguments here. Let me think about this for a minute. Says, well, Miss Carmen, I am inclined to deny your motion, but I will think about it over the weekend, which is interesting. It's not an outright denial. That means there's hope for Carmen. Holy moly. I mean, he basically put her in the timeout chair this entire trial. She's been sitting back there in the corner, squirming in her seat. And this judge won't even listen to her. Says, no, I don't even want to hear your rationale for your objection. Just automatically no. It's like that scene from Austin Powers. Zip, zip, whenever he was doing whatever that scene was. Now, we'll wait until Monday for the government to rest in case they need to come up with anything else over the weekend. The judge says, how do you want to proceed? All right, Tuesday is going to be a half day for the jury, so it'll be a light day for us due to a juror's problem. But he says, my inclination is to just recess now and we'll be back on Monday. Defense attorney for Nordine says, well, look, we can break now, but I still want a ruling. We've got a pending motion to quash. Apparently there's a motion under seal that we have not seen yet relating to a trial subpoena. Judge says, oh yeah, I forgot about that. Yeah, I'll try to get to that over the weekend as well. And okay, well, that's what we've got on my docket. I'll take a look. It's Friday, everybody. Have a great trip back home. We are recessed. We'll be back Monday, 9 a.m. Hope to see you then. So that is the end of trial day 39. Once again, courtesy of our friend Roger Parloff. Excellent follow, doing great work. Senior editor over at Lawfare. We're grateful to his work doing these live tweets threads so that we can dig into them. So that was it. Short trial day. We can see we're done with testimony for the government. That means next week it's going to be the defense case. And it's been 39 days of the government's case. The defense case is going to start tomorrow, presumably. And of course, we will cover it. But let's take a look at what is going on in the case, because there were 2 additional motions that are interesting. The government is replying. No, remember, let's go through these 2 items here in the case. Remember that there was a motion to dismiss that was filed by the defense. They said that after the Tucker videos came out, after we heard about all of those missing spreadsheet rows, after we learned that the government was snooping on attorney-client emails and so on, we wanted a dismissal of the charge due to the egregious misconduct. So this motion was filed by the defense, by Ethan Nordine. No, this one was filed by Dominic Pizzola. And Dominic Pizzola was asking for a motion to dismiss The government replied to the motion, and this is Pezzola's final reply. So it goes, you file the motion, then there's a response, and then you reply to the response. I think I said that wrong the first time. This is the final motion, the final reply. The moving side gets to go first, and they get the final word. So this is what that looks like, they say. From Dominic Pezzola, this is Defendant Pezzola's reply to the government's opposition to the motion to dismiss. First, they write, the government claims that there are no Brady violations associated with the revelations that Tucker Carlson exposed that do not withstand scrutiny. The televised program, they write, was in receipt of tens of thousands of hours of footage from J6, which was previously withheld. The footage reportedly came from the House of Representatives. Although every defense lawyer in every J6 case attests that they have not seen all of this evidence, the government claims that all the footage was provided to our clients. Pezzola submits that although his counselors have viewed many hundreds of hours of discovery, they were unfamiliar with the Tucker Carlson footage relating to Jacob Chansley. All the footage of Chansley that aired on Tucker had been produced to the defendants, says the government. But they say they never saw it. Now, Pezzola, they write, has been deprived of the footage in question. The footage in question is exculpatory. It would show his innocence in that it refutes or rebuts and debunks the arguments of the government that J6 demonstrators forcefully battled their way through the Capitol. An evidentiary hearing is required to determine the extent of these violations. He says, among the trilobytes of discovery, is that a formal unit of measurement for data? Trilobytes of data. I don't know. Maybe I don't know. Of discovery provided by the government are drop-down internal communications between FBI special agent and other agents. From the context, he says, it is clear the message contains messages pertaining to the Proud Boys. This is where he's talking about all of those Excel spreadsheet rows that were hidden. FBI agent Nicole, she testified. They say, well, oh, you talked about text messages in your internal Slack system. We'd like to see those. She said, no problem. I'll do an export. I'll send you what you need. She sent an export. It contained thousands of rows of deleted stuff. They looked in the deleted rows. They said, uh-oh, that looks like it relates to our clients, the Proud Boys. And then the FBI said, wait a minute, you weren't supposed to see that. That was all classified or designated FBI sensitive material, which they just made up out of nowhere. And the judge said, that sounds great. That means that we don't have to look at any of this stuff, and I don't have to tell the jurors about you telling your boss to delete 375 or 378 bits of evidence, and so on and so forth. So the defense continues. They say, Judge, from those rows, it is clear that the FBI agents are comfortable talking to each other about violating the most basic rights of the defendants and the most fundamental rules of evidence gathering. Yeah, and they talk like, I don't know, probably, high school kids talk on their Slack channels, I guess. Strange behavior. They're using weird vernacular. They're FBI agents, so yeah, you can get the point of it. But the agents speak of altering an official report, of destroying hundreds of pieces of evidence. The government disputes the nefarious conclusion. But this is what they said. In quotes, in the report, you need to go into that CHS report, that confidential human source report, and edit out that I was present, which was in the hidden messages. The United States claims that a message by a high-ranking FBI official directing FBI Nicole to go into the report and put in and edit out that I was present was part of a harmless review. They say, like other reports, these are reviewed for accuracy, and it was just inaccurate, and we just needed to make a change. That's all. They say, according to the government, this was their excuse. They say that message referred to an email sent by the CHS, who is an online researcher and not a member of the Proud Boys. The agent who sent it had recently transitioned to a supervisor role and was no longer the handler of the source. He also had not realized he was still copied on the emails. The supervisory agent made the request to edit out his name because he believed he was not copied and thus not present for the purpose of the contact. And because per FBI policy, he cannot approve the write-up of a source meeting he was involved in. After Agent Miller told the supervisory agent that he was in fact copied on the email, he withdrew his request to not be listed. A different supervisor approved the report, and the online source was instructed not to CC the other agent in future emails. Oh, that's all. In short, the exchange concerns a routine clerical matter and does not suggest any wrongdoing on behalf of the FBI, which never makes any mistakes ever. Counsel for Pizzola, they say this is ridiculous. They say this tortured proffer is nonsense. It simply does not explain the wording of the message. Here's what the message said. It said, you need to go into that CHS report and edit out that I was present. That's what it said. One can think of 100 different ways for a superior to command an inferior to engage in a routine clerical matter as described. Yeah, this is a lot. This is like 5 or 6 people involved in this, right? Not the source meeting, email from an online source withdrew his request, a different supervisor approved the report, then the online source was instructed not to cease. It's like a bunch of stuff happened here. But that's not what they said. This was one Slack message, link message. Go in there, edit the report. Note that the message used the word present, right? Not CC'd on the report, not listed, not copied. The government's explanation doesn't name the names or provide the necessary details to support their explanation. Just take our word for it. Who were those other supervisors? Are those other emails popped up? Is there a reply in there saying that don't copy us in the future? Can you produce that email and make that proffer present to the court or not? Or we should just take your word for it? So Pizzola is entitled to see the documents in question, they say, without any redactions or with redactions if you need to. And we want to subpoena everybody else who was involved. There was another couple messages that were in those deleted or hidden rows, one of which was, my boss just ordered me to destroy 333 pieces of evidence. That's a little unusual in a quick message. OMG, that's insane, like high school girls. At the FBI. Now, next, they say the government desperately seeks to cover up an obvious, potentially earth-shattering corruption scandal by merely proffering that a text message saying, my boss ordered me to delete and destroy 338 pieces of evidence. I don't know what it is, 334 or 338. But if it's 338 pieces of evidence with an exclamation point, they say that that was not harmless, innocent, or legal. But if there was anything routine, innocuous, or mundane about such a message, the characteristics are belied by Agent Miller's shocked response. She said, OMG, that's insane. They said it's just routine. Why is it insane, exclamation point, to destroy 338 pieces of evidence if it's so harmless, innocent, and legal? Now, even under a perspective extravagantly favoring the government, this exchange cries out for an investigation by the court. Yet the United States responds by misframing the issue as one of the other agents' destruction of unrelated evidence. The government continues, they say, as the court knows, disposal of evidence is a routine part of the life cycle of every criminal case, and the process occurs through the manual. And they reference the manual and they say we did everything fine. But they're referencing this manual. It says here, the destruction of evidence in this case was about 338 items of evidence from a 20-year-old multi-co-defendant trial. Now, the defense says that's very convenient, that they just conveniently delete evidence and it happened to show up and it's just a routine matter. As Root stated in court on Monday, he said that the government's proffer doesn't pass the smell test. Says it's difficult to imagine an FBI agent saying, quote, my boss just ordered me to destroy 334 pieces of evidence. If the agent meant to say, my boss just ordered me to follow the Bureau's procedure for disposing of evidence in closed criminal cases related to a multi-year co-defendant case, right? It's a little bit different of a tone. My boss just ordered me to destroy this stuff. OMG. A little bit different than, hey, can you close out the Smith-Johnson case? The evidence needs to be put through the closeout procedure. Yeah, take a look at the manual, follow the instructions there. That person says, is that an, oh my gosh, is that type of a response? Or is it a response like, I got to go delete all this, destroy all this stuff. The government offers no hint of the identity of the boss. Who made that order? Don't know. The names of the co-defendant case should be public record now, right? It's very old. Can we see what case it was? And follow up to make sure the evidence was destroyed? Or 3, how about the names of the defendant's family who supposedly received some of that evidence back? Can we verify any of that? No. Indeed, the proffer contradicts the original message in material ways. The original message indicates that a high-ranking FBI officer had a lower-ranking officer destroy 338 pieces of evidence. But the proffer filed by the government says it's just routine. And why would Special Agent FBI Nicole respond with, "OMG, that's insane!" exclamation point, to a statement about disposing evidence of a 20-year-old case? Seems unlikely. Conclusion. Roger Root says, Pizzola prays for an evidentiary hearing into these matters, the witness subpoena to testify under oath, and additionally requests a mistrial and a dismissal. So that'll be the final word on this, and then this will go back over to the judge who will issue a ruling on that sooner rather than later. My guess is going to be that it's not going to be dismissed because that's sort of been the pattern on this trial. I don't even think we'll get an evidentiary hearing on it, but we do have some updates on how this trial will proceed because the judge issued a new order filed on March 16th. This is the latest update as to the rules for the next half of this trial. Now, they say, upon consideration of the government's request for additional procedures, you remember last week we read the government wanted all of these rules. They wanted the defense to notify us about who's coming up next and who your witnesses are and where your exhibits are and all this stuff. And the defense said, we don't know. We fly by the seat of our pants, some of them. And they said, we think this is the more appropriate way to structure this. A lot less rules, a lot more fluid, organic. And they were proposing sets of rules for how the defense is going to be calling their witness and how they're going to be presenting their case. So the judge just decided this. It says, it is hereby ordered, and the motion is granted, ordering the following be done. First, the defense shall present their case in the order set forth in the indictment. So you remember the order of the indictment is exactly how I have them listed here. Okay, so I have each co-defendant. The first co-defendant is Ethan. Second is Biggs. Third is Real. Fourth is Enrique. Fifth is Dominic. So they'll go in that order, is what the judge is telling us. Says, however, if more than one defendant intends to call a witness in his case in chief, he may do so out of order. If more than one defendant intends to call the same person, may call them out of order. So like if co-defendant 1 and co-defendant 5 want to talk to the same witness, co-defendant 5 may be able to jump in on that first witness's testimony. And we may be spending another, week or 2 weeks or 4 weeks. We don't know how far this will go. Says, each Friday before and during the trial, defendants shall provide to the government an order of call of witnesses for the following week. Defendants must also provide a list of witnesses they anticipate on calling on a particular trial day, no less than 36 hours in advance, if not earlier. Counsel will not be absolutely bound by these witness lists or order of call, and if in good faith they need to change the order, or if necessary to call a witness out of turn. Now, any defendant calling a witness shall provide the Jenks materials, which we learned all about, I think 2 weeks ago, and the exhibits it intends to use during the witness testimony no later than 36 hours before he intends to call the witness. Any objections to the exhibits that cannot be resolved. So exhibits versus, okay, here. The government shall designate any Rule 106 materials. These are all discovery types of things. Cross-examination of the defense witness by co-defendants shall be restricted to that testimony that is adverse to the co-defendant. Okay, that's interesting. So just like we heard today, if if one defendant presents one witness, they don't get to ask him about all of his all of his direct testimony if they're cross-examining somebody. Only the part of the testimony that implicates their client. But I think a lot of these witnesses are going to be good for all of them. We'll see. We'll have to see. We don't know. Now, the court, in other words, we don't know if the Proud Boys are going to turn amongst themselves and they're all going to start pointing fingers at each other. We're starting to see some of that right now. But whether they do that in their case in chief, we'll see. The court shall inquire of the defense at the conclusion of the witness whether any co-defendant wishes to cross-examine the witness, and if so, demonstrate the nature of the adversity. Yeah, so for example, you could bring in Enrique Tarrio could call a witness that's very helpful to him and maybe 3 other guys, but bad for Dominic Pizzola. And then Dominic Pizzola might want to cross-examine that witness, or all the witnesses might be great for all of them. We don't know. So looks like that is the final part of the order. So ordered March 16th, 2023 by Judge Kelly. And so we'll be back in court tomorrow with the full trial proceedings. We see the service dog hopefully will be allowed to join. I mean, these prosecutors are just such killjoys, but we will continue to cover. Thank you for subscribing wherever it is you're watching this, and we'll look forward to seeing you on the next one. But how important it is to be healthy and green, courtesy of our friends over at fieldofgreens.com. And my friends, I want to tell you that it is a time for us to decide to lose some of those leftover pandemic pounds. And we're all sick of the fad diets and the weight loss pills and all of those things. We've all been there. We've all done that. We know they don't work, but you know what does? Eating 5 healthy servings of fruits and vegetables every day. You do that and the weight would probably fall right off. But look, vegetables, not a fan, and fruit, who's got time to prepare that every day? Instead, let's talk about Field of Greens. Now, Field of Greens is a science-backed formula, very specific fruits and vegetables that you won't find in any other product. Proper nutrition reboots your metabolism so you can burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. You're going to look healthier, feel healthier, but the greater proof is going to come at your next checkup when your doctor says, wow, you've lost weight. Whatever you're doing, keep it up. And so let's get you started. Go on over to fieldofgreens.com. Don't forget to use code Robert to save at checkout. The vegetables want to be eaten. You're going to be feeling amazing, bursting with green energy, the good kind of green energy, out of your hair follicles, maybe. I don't know. That's not FDA approved statement. However, it is great stuff. Fieldofgreens.com. Don't forget to use code Robert at checkout.